Hello everyone, how are you? I hope you are all well and healthy. Today, we're going to delve into the legal distinctions between admission and confession. Difference between admission and confession. Admission. If a statement is made by a party in civil proceeding, it will be called as admission. Confession. If a statement made by a party charged with crime in criminal proceeding, it is called as a confession. Admission. The expression admission means voluntary acknowledgement of the existence or truth of a particular fact. Confession. The expression confession means a statement made by an accused admitting his guilt. If a person accused of an offense, accused, makes a statement against himself, it is called confession. Admission. An admission is genius. Confession. Confession is specie, hence all confessions or admissions, but all admissions are not confessions. Admission. The term admission is applicable to a statement, oral or in writing, made by a party on civil side. Confession. Confession is the term for admission of guilt made in the criminal side. Admission. An admission is not conclusive proof of the matters admitted and is always rebuttable. Confession. A confession, if voluntarily and free, may in the discretion of the judge or magistrate by itself be accepted as conclusive proof of matters confessed and is alone sufficient to warrant a conviction. Admission. An admission may be proved by or behalf of the person making it. Confession. But confession always goes against the person making it. Admission. An admission may be made by an agent in course of business. Confession. While an agent can never make the confession of an offense against a co-defendant. Admission. Admission by one of the several defendants in suit is not evidence against other defendants. Confession. Confession made by one or two or more accused jointly tried for the same offense can be taken into consideration against the co-accused. According to Kanun-e-Shahadat, 1984. Hearsay rule states that what is clearly expressed about the fact under discussion is irrelevant. Admission and confession are two exceptions to this rule that are commonly juxtaposed. In general sense, admission means admitting of any fact as true. It suggests conclusion on the liability of the person who makes the statement. On the other extreme, confession implies a statement which outrightly admits the suit. A confession is made by the person under indictment, which proves a criminal offense committed by him or her, while a confession is a conclusive proof. Admission is not considered as a confession. The article except sheds light on the difference between confession and admission. Take a read. To sum up, it can be said that the admission has a wider scope than confession, as the latter comes under the ambit of the former. Hence, every confession is an admission, but the reverse is not true. The main difference between these two is that in case of confession, the conviction is based on the statement itself. However, in the case of admission, additional evidence is required to support the conviction.
हेलो सब, कैसे हैं आप? मुझे उम्मीद है कि आप सब ठीक और सेहतमंद होंगे। आज हम दाखिला और इतिराफ के दरमियान कानूनी इम्तियाज़ात पर गौर करने जा रहे हैं। दाखिला और इतिराफ के दरमियान फ़र्क। दाखिला: अगर दीवानी कार्रवाई में किसी फरीक की तरफ से कोई बयान दिया जाता है तो उसे दाखिला कहा जाएगा। इतिराफ: अगर किसी फरीक की तरफ से जुर्म का इल्ज़ाम फौजदारी कार्रवाई में दिया गया बयान, उसे इतिराफ जुर्म कहा जाता है। दाखिला इजहार: दाखिला का मतलब है किसी खास हकीकत के वजूद या सच्चाई का रजाकाराना इतराफ। इतराफ इतराफ का मतलब है एक ऐसा बयान जो किसी मुल्जिम ने अपने जुर्म का इतराफ करते हुए दिया हो। अगर कोई शख्स किसी जुर्म का मुल्जिम अपने खिलाफ बयान देता है तो उसे इतराफ जुर्म कहा जाता है। दाखिला एक दाखिला बासलाहियत है। इतराफ इतराफ एक मखसूस है, इसलिए तमाम इतराफात दाखिला है, लेकिन तमाम दाखिले इतराफात नहीं हैं। दाखिला टर्म एडमिशन का इतलाक सिविल की तरफ से किसी फरीक के जरिया ज़बानी या तहरीरी बयान पर होता है। इतराफ जुर्म के इतराफ की अस्तिलाह है। दाखिला दाखिला दाखिल किए गए मामलात का हतमी सबूत नहीं है और हमेशा इनकार किया जाता है। इतराफ इकरार अगर रजाकाराना और आज़ाद है तो जज या मजिस्ट्रेट की सवाबदीद पर बजात खुद इकरार शुदा मामलात के हतमी सबूत के तौर पर कबूल किया जा सकता है और सजा की जमानत देने के लिए अकेला ही काफी है।
ठीक है।
दाखिला एक दाखिला उसे बनाने वाले शख्स की तरफ से या उसकी तरफ से साबित किया जा सकता है।
राइट।
इतराफ लेकिन इतराफ हमेशा करने वाले के खिलाफ जाता है।
राइट।
दाखिला कारोबार के दौरान एक एजेंट के जरिया दाखिला लिया जा सकता है। इतराफ जबकि एक एजेंट कभी भी शरीक मुद्दा अलैहि के खिलाफ जुर्म का इतराफ नहीं कर सकता। दाखिला मुकदमे में मुताद्दिद मुद्दा अलिहान में से एक का दाखिला दूसरे मुद्दा अलिहान के खिलाफ सबूत नहीं।